Welcome to Namefi podcast. Namefi is a blockchain technology company that tokenizes domain ownership for trading, DeFi, and an ownable internet. We regularly hold Twitter spaces and have conversations with our founder friends, partners, and community members. We turn our conversations into this podcast channel. If you like it, follow us on Twitter at Namefi_IO. NAMEFI_IO, and join our next live Namefi space. Thank you. Hey everyone, thanks for joining our domains, disputes, and due diligence with our friend Brett E. Lewis. While we're waiting for Brett to come on board, we have a few minutes that we want to randomly chat and get to know people. Hey, can you hear me? How's it going, Aris?
Not too bad, not too bad. Yeah, no, the history of the domain social is, so in 2020, when the pandemic started, I'm pretty sure you know who Michael Seiger is.
Of course, what a legend.
So he, like, pretty much the first week when things shut down, he started what he called pandemic social. And he just, he spam, no. he sent out like a whole, to all his whole mailing list, invitation to a Zoom. And he held the weekly sessions with that until was it end of June or end of July of 2020. That was funny because then he said things are, because, with COVID, things were up and down, right? At a certain point, we thought things were getting a little bit better in the short term. He goes, things are opening up a bit. He wants to spend the summer with his family, whatever. So he's like, I got good news and bad news. I said that was the good news, that things are opening up, but the bad news, like, that was going to be the last Friday. He used to do it every Friday. And he goes, if anyone wants to take over, let me know. So me and a couple others put our hands up. And in the end, I kind of was when I took the lead on that. And I wanted to get domain social because it was a social, right, that we were doing on Zoom every week during the pandemic. But that was taken. So I just registered the domain social. It's just with domain investors. So it didn't really matter. So I used that for people to register. And I would send out an email sort of every week to say, okay, yeah, we're going to do it. This is the Zoom link, right? Because we did it on Zoom. But so that's where it came from. So it's not necessarily the greatest, I don't think it's a great Twitter handle, but I used this account to basically promote the weekly sessions. And I put the notice up the day before and I'd say what the topics were. And we did some auctions and whatnot. So I'd say what domains were going to auction. And that's how the Twitter account, and it grew and grew. And then I had a couple other accounts. I wasn't really a big Twitter user. And so that ended up being my main account. I'm probably going to change the handle at some point. But we still do them every now and then, but it's not the weekly thing it used to be. But partially because I'm taking care of some family health issues. I got three different family members with mental health issues, so it's been challenging to figure out a routine and a weekly date where I'm really truly available without the danger of the phone ringing type of thing. So I've kind of taken a break on that. But some of you others have taken over, right? These sessions on Twitter, X, you want to call it, is kind of the new thing now. For a while we were on Clubhouse as well, so that kind of was a thing for a lot of domain investors for a few years after Zoom and before Twitter Spaces. But things evolve over time. But that's the origin of the name. But it's nothing really too fancy. And I'm like, I got to change it because at some point I have to have my own sort of handle for myself as opposed to like just the sessions. But it is what it is. It's not too important, I don't think.
What a story, Arif. What a story. Of course, first of all, my heart and prayers for your family members who is struggling. Hope them get better soon. Hope them recover. And hope that it gives you more liberty to serve the community. Of course, you have to serve family first.
Yeah, it's like dementia, Alzheimer's, and autism. So things aren't really going to get better, but like I'm hoping to manage the situation better to get more free time exactly for that. So I hope to get back into things, soon enough. But it's good to see guys like yourself, sort of. There's always going to be new people filling the role, and it's good to have leaders in the community to sort of start these rooms, because I think it's important to have community discussions and get feedback from other people, because it's if we only listen to ourselves, we never really grow, right? So it's good to have rooms like these.
Yeah, totally. I think the part that I'm really moved is that you step up and took over when good news and bad news from Mike Seiger. He has to let go his weekly commitments, and then you and other community members step up and took over and continue to grow the community and to serve the community. I truly like resonate with that. I did a lot of community building in different areas. Twitter space for domainers is just a part of it, but also many other things. It's not easy, right? Like have weekly commitments to go up and then create a venue for people to talk, to say hi to people, to make people feel they're welcome and they can hang out, they can be heard. It's not very easy. So my kudos to you. Does it still happen these days? And then whether people can go and sign up the domain social
Yeah, they can still go to the domainsocial.com. I probably do one every few months just to like, okay, we'll get back into it and whatnot. I do plan to get back to it at some point. And Zoom was a little bit different because you could share screen, right? So we're talking about stuff, and when you see people on camera, the social element is a little bit more enhanced. You just facial expressions, sometimes it makes a difference. I mean, just audio is certainly better than text, right? You have like the bare basics is text, where things can often get lost in translation, or one missing comma could make the difference between an aggressive response and a friendly response, right? And so like here, at least you can hear the tones of people's voices and whatnot. And but yeah, video, I think it takes it another level. Plus you could share stuff. So yeah, I mean, the domain social, it's there for people who want to register. And whenever I do a session, again, because it's Zoom, it's not as easy to promote, right? So I basically send out an email with the link. I usually do one email 1 or 2 days before, and then right at start time I'll send another email so it's at the top of people's inboxes, and you just click on the Zoom link. But yeah, my plan is to get back into it. I did an online conference in 2021 as well. That was pretty big. It was like 9 days, 50 hours, about 50 speakers, leaders in the community. That was cool too. So I do enjoy doing that kind of stuff. But as you said, it's a lot of work, it's a lot of commitment. So like people like yourself, and there's others too. I won't name names because there's I'll always miss one, but we all know who they are. People who filled sort of like the role of community sort of gatherer, I guess is probably the right term. And just as you said, it's not, people think it's easy just to turn on the mic and whatever it is, but no, people, you gotta plan stuff a little bit ahead of time. And you have to block off that period of time week after week after week. And when you do it a few times, it's like, okay, it's not so hard. But like after a while, it's like, oh no, you are putting some things aside, right? So again, big thanks to the people in the industry who take on that role and make consistent spaces or clubhouse rooms or whatever it might be.
Absolutely. I think whoever takes up that role, step up and serve the community, deserve an applaud and then a shout out. All I want to build domain is partly because I think domain is a great tool to engage with community, not just because a place, right? But also, as you might seen, you might have been, if you followed our feature release, we're rolling out our features called Powered by Namefi, allow people to issue subdomains from the main domains. And therefore your community member can get a name, right? Like maybe you don't need to give up the domainsocial.com. You can be arif.thedomainsocial.com and everyone will remember you as that person who spent and commit a lot of time into this community. You get the reputation, maybe in the future you get some share of revenues, etc. I truly believe domain is a great tool that can enable these kind of interactions and reputation power platforms.
Yeah, I've been domain investing since late 2016, but I got my first domain in 99. I had a online music community. It was more like club music and DJ stuff and whatnot, and it grew pretty big back then. But yeah, I had my forum and I had a lot of members, and it was also a pretty big community, and it was kind of cool because exactly that. I had some people who I had kind of, they weren't really blogs, but they had their own review section and whatnot. And again, I gave them subdomains, right? And I think one kind of half mistake I made was I also on the domain there was a service at the time that would it was like free emails that you hook up to the domain and you could. So I gave like all the members kind of an email. Like in hindsight, it's like yeah, okay, kind of it's kind of. Some people with spammy stuff and whatnot.
Oh,
but it was a cool tool. Like, I mean, it was cool. It was a feature, right? Like, if I was a little bit more selective of who I gave it the emails to, it would have been something cool. So yeah, it was domains can really do some cool stuff for a community building, right? And you could give tools to people, and obviously back, this is, I'm talking like 25 years ago, right? And it was like very early 2000s when I was really doing this, and yeah, we didn't really have like the blockchain stuff and NFTs and whatever we could reward people, like, but it was still like just being part of the community and using those things were rewards of themselves, right? That's why I often see all these gimmicks of people giving away all these drops, and like I go, no, what's the community part, right? Like, what's the community without the gimmicks? Because that's what it really should be about, right? The actual people who want to be there, who don't have to entice, right? Those are the people who really care, right? Who really want to build like the community and not just there because they're going to get some reward.
Yeah, I think what you mentioned is a big problem in Web3 space, right? A lot of time people would like to have a community, and then so they do the airdrops, the free mint, and everything.
Yeah.
But like, if it's not helping the community, the only way it succeeds is actually facilitating community, not in replacement of community. So if nothing, it creates like if it doesn't create additional value, and then if no one is there to build, they're only there to claim something, there's nothing to be really claimed.
Yeah, that's oftentimes like the blockchain names. I'm like, people know I've been I've been a little bit warning people about the actual investment side of it, but I think there's cool stuff can be built on it, but that's all I see, right? I don't really see much people building things. I see people, a handful of stuff, but it's more people, oh, well, you should do this drop. You should give us, you should give users a bonus for this, or you should give, and it's like, no, like you're missing the point. If that's all you're asking for, you're not actually going to build something on the whatever it is, on the blockchain space or the namespace, whatever it is, then like nobody's going to just do nothing there, right? You have to actually build something of consequence that people are going to use, right? And then you need to do it en masse, because look, like .com, there's like literally hundreds of millions of people using it, right? And even then, it's a difficult namespace for investors, right? I'm looking at the investor side, but it's like, here we are, and it's like people are saying, oh, it's the next big thing, but like, if nobody's building websites on it or products on it, then it's like, well, what's going on? And I think we're going to have this hype phase, but like, people think I'm so negative on it, but I'm not. I think there's going to be some cool things built on it, right? And after I think the hype burns off, there's going to be some cool tools there. Like, will it be investable like domains are? I don't really think so, but it doesn't need to be. That's not really the point of it, right? The point is just to have more flexibility and build cool things. And then at some point, there might be something that, value spawns from that out of, that we don't, see coming, but we'll see. But yeah, I agree with you. It's just you got to get the people who actually care about what the product is and use it.
Agreed, 100%. Speaking of getting people to build, we happen to have someone who's a perfect example of not just building it himself, but also enabling a lot of people to build. Founder of WebHash, Hidayat himself on the stage. Hey, Hid, are you at liberty to turn on your mic and say something about the building atmospheres that you were creating?
Hey Victor, hi Alex. How are you guys doing? It's been a long time, Victor.
It has
Uh,
been, yes.
yeah. We so WebHash is growing every day. So now we are 8,000 plus users building decentralized websites. More than 12,000 decentralized websites has been deployed, and as you said, it's difficult to make people build. I think that is the reason user growth is slow, but still we got 8,000 plus users building every day. And recently we launched our node network, where the idea behind the node network is anybody should be able to launch a node by spending only $100, like a Raspberry Pi. So they should be able to set up a node in their home with a Raspberry Pi or spare PC available in the home, and all the websites which is being built will be getting deployed on those nodes, and they will be contributing to the network. And And the important stuff what we're trying to achieve is making these websites, the apps, and content permanently hosted using the community node network. So more than 61 nodes has been deployed in 2 months, and more than 30 TB of storage has been provided by the community. So we are slowly growing, uh, but strongly going. So now we are focusing on onboarding different communities onto WebHash. Like there are different kind of decentralized naming systems available for every chain. Like Solana has its own naming system, Sui has its own naming system, and and Bitcoin has its own naming system. So we thought we should onboard them also into building on their names. It's not only investing in the names, they should use their names and build on those stuff. So recently we integrated Solana naming system SNS into the platform and Sui naming system both. So both communities are being onboarded onto WebHash and building through WebHash and deploying onto IPFS and making sure the content is permanently available in a decentralized way.
That's amazing. I'm so happy to see the continuous growth of WebHash. And I see that you integrate with other Web3 names as well. This is so great. We love to be able to further collaborate with you and then make it also supporting the ICANN names. I think what WebHash did was really innovative, and everyone who's interested should go and check. I also posted a cross post a web hash stats that yes shared on his Twitter. So congrats on the achievement. I think this is a very good example of what Arif mentioned. Like you got to get people to come and build. I think web hash is a great tool. Everyone should go check it out if you haven't yet.
Yeah, so I forgot to mention, Team is working on integrating free Namefi contracts into our platform where they should be able to build on tokenized DNS domains and connect the decentralized websites to DNS domains. So we built gateway technology where decentralized websites should be connected to DNS domains and accessed through DNS domains. So it will be live soon.
That's awesome. Look forward to it. I think it would make Arif happy as well.
So what is going on Namefi? I saw a lot of developments in Namefi platform with the AI and all those stuff. Is there any new news?
Yeah. I think we have a lot of features that we're rolling out, such as powered by Namefi, which is allowing people to issue subdomains from the main normal domains, as we say it. And then it also will create additional can of worms potentially. Like if you allow people to use your domain as a subdomain, uh, maybe they will do it right and build great things. Maybe some people will do it wrong, and then you have to have a way to make sure it doesn't happen. So that's why we were talking to some of the best minds in the industry about the domain and disputes and due diligence. Like that's a part of the motivation that we go there and then seek some of the best mind to for conversations. I don't know if anyone have got into this land because domain is a piece of very precious digital asset. And then if it's used right, it can build skyscrapers and big cities and town and shopping centers. If it's done wrong, it can also be misused very much. So I wonder if anyone have personal experience or have heard about experience about any dispute in the past.
Dispute, if you dispute, there will be issues, but the idea of tokenizing and fractionalizing the domain is a superb idea which we are trying to solve through websites. Like if you build something on domain, you should be able to tokenize it and fractionalize it. And if you want to raise investment through name or through the product which is built on the name, this will be the great idea. Like provide subdomains which will be decentralized DNS domain, tokenized on blockchain, and give the ownership of the domain based on the subdomains, and collect investment or raise investment through providing subdomains on a DNS domain. That will be great use case, Victor.
I see. Yeah, cool. Good to know. So Arif, I wonder if you in your domain social, anyone have mentioned that they run into these kind of disputes either on the offense side or defense side, whether people like need help at the time. What was the situation if you remember?
Oh, well, there's tons and tons of situations, like, people have UDRPs and whatnot. I personally, I've been pretty careful to steer clear, but again, it's thanks to people, experts in the field or lawyers who share the information. Right? There's a handful who really are good in sharing information on the podcasts and the forums. But yeah, no, all the time there's issues, and that's what you gotta be careful to steer clear of, trademarks and other people's business names and whatnot. And it's that's where I think with the blockchain stuff is it's a double-edged sword, right? I mean, in one sense, people say, oh yeah, you can keep your domains a lot more, nobody can take them away. But on the other side of things, that's actually negative, right? So because if somebody's infringing on a trademark, in an abusive way, you want to be able to take that away, right? And so the inability to do that can be challenging, I think, for especially like Web3 focused things. But there are some solutions to it, but it's not easy, and it's not easy on either side, right? And the problem with trademarks and the other regulations is that it's not always like black or white, right? There are gray zones. There are nuances. There are like cases where a trademark could be viewed by a judge or panelist to be infringing, and by the next judge or panelist not to be infringing, right? And that's where it gets really complicated, and that's where it's really important to build your knowledge of the legal aspects of domains, because it's not that simple. But you really want to steer clear of them, because it's at a certain point also, people are too much on the infringing side. It makes our whole industry look bad, right? But at the same time, you don't want to miss opportunities where it's actually not a trademark, but you think it is, right? So knowledge is really important in this sort of discussion, in this legal framework with domains, because it really, if you know what you're doing, you can avoid some big problems, but you can also find opportunities that other people think are problems but actually aren't.
Yeah, that's true. I think you make a very good point that actually being able to protect brand, protect trademark makes domain valuable, right? That's how people know it is okay to continue to build upon, let's say, some .com domains, because they know their trademark is going to be protected as a whole. And then I also love to kind of share a little bit of a recent case of my founder friends who run into the problem. But before that, just want to say hi. Say hi to our good friend Amit Gupta, who just changed your Twitter profile picture. Is that right, Amit?
Yes, Victor. Very good evening to you, or morning, depending on where you are.
Yep.
And very good evening to all the people in the space. I just joined, so I'm not very sure what's going on, but I'll catch up.
Yep. We were just beginning to discuss the domain disputes and due diligence. I personally have a friend who built a project, and her competitor actually registered another extension and then directed to their own project, and then that give her a lot of trouble, and she has to kind of find help. On one hand, it's a pity that she didn't get to protect the extension early on. There's many ways you can register them. I think you also have some general block way to let your registrar block the same string over the entire list of extensions. But like once it happens, when someone else got your domain, there's things that the domainers can do to kind of sell the domain and negotiate for a good price. But also there's mistake that domainers can do that causes a problem and potentially a dispute and lose their domains. So I think it's beneficial for founders to know their rights and the urgency to protect their domain, but also for domainers to know their own rights and also what to do and what not to do when they're trying to kind of use a domain and then protect them and then maximize their profit from owning a domain. So I'm personally very curious, but also I want to hear stories. That's why I want to have this Twitter space today.
So, Victor, if somebody is trying to infringe on your trademark, you cannot stop them. There are so many extensions that they can register in. I don't think there's anything that is stopping from people if they want to infringe on a trademark by desire. As an investor, there are so many steps that you can take that you do not stumble upon any such thing. I can list out those.
Oh yeah, love to hear. Yeah, love to hear like what's the typical way to make sure you don't do wrong thing to lose your domain and then you can protect your domain.
Yeah, my philosophy is prevention is better than cure. So before registering a domain, I do my due diligence. First thing is Google search those keywords together and see if any brand you are infringing. That's the first thing. Second thing, even on Google, just use the brand with the term UDRP, because then you'll know if any of those people have previously filed any UDRP cases. Then there is this website called branddb dot, let me see, branddb.wipo.int. There you can check all the trademarks that are registered. So you make sure that there is no trademark registered in 41 class, sometimes in other classes as well, but 41 is important. These are the 3 steps you can do quickly to see if a domain is trademarked or not, or if even part of domain is trademarked. It depends on how better you search. Other than that, if somebody wants to infringe on your trademark, like it happened with your friend, nothing can stop them. If I have to find a domain with the SLD Facebook on it, I can register it today.
Yeah, that's true. I think it's a very high bar to claim that to assert someone is actually infringing. And then so if as long as you don't do the wrong thing that actually confuses the consumer, I think it's legally allowed to hold domains, right? The problem is sometimes people try to get in front of people and then try to potentially confuses their customer. That's when those behaviors are considered infringing. So holding domain itself is not. I think it's not infringing.
It depends. Like really, what you're right. Usage is the most important thing when it comes to actually having a mark, like and maintaining it, and also the infringement part. But there are cases where simply holding the domain, like it depends on the domain. Like if it's very distinctive and like not necessarily keywords, but more of a brandable or made up words, or maybe the term often people use is fanciful. In that case, yeah, if somebody if it goes to UDRP, and it goes to a panelist, and he goes, yeah, that he couldn't imagine somebody registering that domain for any other reason, then it could be taken away from you, even if you're not using it. Again, context really matters, and that's why listening to many rooms like this over and over again and hearing all the different examples really matters, because it's not always a yes or no thing. It's like, okay, what's this? What's the situation? What happened here? Why did this happen? Why did you register the domain? What information was available at the time? All these things kind of matter, and it's like it's never a clear response. But yeah, just be careful, because owning a domain, yeah, it can get you into trouble, right? And you can lose a domain just by owning it. But as you said, not always. Sometimes, it's only if you're using it improperly.
Yeah, I truly agree. And I think Arif gave a very good example. I also want to surface what Amit just mentioned, 3 things to search. Search for the name for the brand, search for the brand space, UDRP in Google search to see if there is an existing UDRP proceedings. And also search for the 3rd link that I didn't know. So Amit, if you can post it on Twitter and share into this group, that would be great. I would like to kind of feature it and highlight it for everyone to follow. And also, speaking of the resources, I also want to highlight our good friend and someone I really respect, Todd Ryan, who is also in the audience today in the listening. He regularly, with other great people, runs UDRP and other legal matters of domains, Twitter space, and other resources. So you should go give him a follow, check him out. And also, Hit, you have your hands raised. Go ahead.
Yeah, there was some drama in India where 2 siblings from Dubai squatted geohotstar.com. GeoHotstar is a OTT platform in India. so which is acquired by Disney, I guess. Disney Hotstar is partnered with Geo in India, and that app is named Geo Hotstar. And it has become a huge drama in India about UDPR and all those things. So eventually, those siblings has transferred the domain to Reliance Geo, which is a multi-billion-dollar company, where initially the siblings announced that if Reliance Jio wants the domain, they should pay 1 crore. It is around $120,000. Then they can acquire the domain. But after some months of huge trauma in Indian domain ecosystem, they eventually transferred it. I think they understood the legal perspective around it. If Geo goes to court, obviously court will ask ICANN to transfer the domain ownership to Geo Hotstar because of these trademarks and copyright ownerships and all those stuff.
You are very misinformed, my friend. There was no UDRP for that domain. That domain was registered long before, or a bit before, the company took that GeoStar name. They transferred the domain out of pressure from the Geo company. The circumstances of that are not known to me, but there was no UDRP involved. If they wanted to keep a domain, or let's say somebody from United States would have had that domain, they could have done very little to get that domain.
Maybe. We read in news whatever news is there, but the siblings has announced there is no pressure. Yeah, obviously we know in India, if they announce there is no pressure, there will be something behind it.
Yeah, like people give away things without pressure.
Yeah, it happened with me in 2019. I run a product called w3layout.com, which is a free templating platform like Theme Forest and those stuff. In 2019, the biggest party in India called BJP, which runs the government, their website got hacked in the phase of elections. But their developer, what he did, he took our template. He did not pay for the template. He removed the copyrights from the template and used it for their political party. There was a huge drama around it. Every news channel started speaking about it, and I too announced that there is no pressure, but there was a lot of pressure from the politicians and the fans of those political parties and those stuff. So eventually, I closed the dispute, saying that there is no pressure from anyone. We have to close this drama around copyrights and those stuff. See, India doesn't have that much strong copyright laws and those stuff, where you can go to court and fight with these politicians and get compensated for what they have done.
Yeah, that's why it's really important to know what your actual rights are and what the rules are, right? Because sometimes exactly that, you might give away something unintentionally thinking that you're breaking the rules. Like it happens quite often. It happens regularly that, lawyers for these, big trademark brands will, send out you scary letters, right? Saying, oh, you have to, transfer the domain and blah, blah, blah. And I've known people who've given away the domain because of fear of getting an email from a lawyer, right? Whereas no, it's actually, they didn't need to give it away. And in some cases there are people who infringe, but in some cases the name was not infringing. It was a generic word that obviously the brand had usage of, but just because you use it as your trademark doesn't mean it's exclusive to you. It really depends on how much usage there is, how famous the mark is. There's a lot of things that come into play, and especially if it's a generic word or generic words, then you probably have a lot more rights than you think you do. And the problem is that you often get these letters from lawyers, and the bottom says all these these official titles, and you get like, oh, if you don't know any better, you could be really scared. But the fact of the matter is, sometimes they're meaningless accusations, and they're just there to pay their salary. They have to justify the make work, because a lot of these big companies and marks, they just hire staff that do this. And it's like the staff doesn't really look at each case by case. They just send out a whole bunch of emails, and for every 100 emails they send out, they'll get 5 people who give up the domain, and it makes it look like they've done their job and they've protected the things. But in reality, it really wasn't something the domain investor should have given up. Right? In some cases it is. That's why, again, it's really important to know what the rules are. And as you said, I just want to shout out also to Todd and him, David, and Jeff put on an excellent show week after week. So if you're interested in this kind of stuff, they're good people to follow as well.
Also, I want to clear that my knowledge about Geo Hotstar case is limited, but I'm very sure the UDRP was not filed. It was managed before the UDRP, but the domain had two trademarks, Geo and Hotstar, so it was open for UDRP if the companies would have wanted. But I didn't think they went there because I cannot find anything about it. Also, I shared the link to you, Victor.
Yeah, I also just shared some concept called adverse possession. That's a common law concept that I learned when I come to US. I grew up in a, I think it's a continental law system where like many rights are defined in a statutory terms and systems and lines by um, legislative bodies. But when I come to the US, the common law system is very interesting. This concept, adverse possession, actually is, to my understanding, a large reason why the trademark rights is created. And then, of course, if anyone is in the legal practicing space, please correct me if I was wrong. Sometimes you have to defend your rights in order for the rights to stand. Actually, a fun fact is that there was this company in China uses the Jordan of Chinese translation as a brand, and then they, of course, after a while, Jordan team go and filed a trademark lawsuit in China, and then they end up settling not in the best term because partly because the Jordan of the China Jordan back then, one of the evidence they present is that they actually advertise Jordan in many of like NBA teams, and then Jordan, the US Jordan team didn't actually complaints. And that was used in a lawsuit and arbitration as a demo of, okay, you didn't care or you didn't consider this as your right, so you don't use it, you lose it type of thing. So I think this is a very interesting legal landscape and also very innovative sometimes. I'm puzzled many times. So that's why I'm very, very fascinated and curious about the space.
Yeah, 'cause people think like, just because the only way a trademark is a trademark is if it's registered, and that's just not the case at all, right? It's really comes down to usage, and as you said, like you need to protect your brand. Like your usage matters, how you promote it matters. If you lay off, there have been cases in the past. I wish I could think of one right now, but where trademarks have actually been dissolved because that mark kind of got known as the actual generic, right? Like look, it's not the right example, but like something, let's say, like for me, I always use Kleenex to mean tissue, right? And if Kleenex doesn't promote their brand as their own actual product, that's a danger of losing that if that becomes, if too many people use it as a generic. So yeah, usage matters, and it's really the nuances, unfortunately, are more important sometimes than what's written on paper, black and white. And that's why, again, knowledge is really important in this matter.
Totally. I think you make a very good point. I think if anyone use Google too often and then even use Google in the terms of search in their own search products, and then it could Google, if Google doesn't defend it, it could lose the fact that Google is a special term. There's many times when a very successful product make the debut, becomes very highly adopted and big usage, and then become a verb and get into dictionary. That's like a happy problem to have, but also I think from a trademark perspective, it's going to be interesting for them. Another example I can think of is when X, like when Twitter was renamed to X, right? There are actually many products that has a name X or X as a substring in it, right? If you go to Google, I think Google has a company called X Company, the research company that's under Alphabet. And today, if you go there, you will see that under X.company, there's a little line says X. We go to Twitter, and then this is not us, right? So that means they're not trying to kind of fight X, Elon Musk as taking the X as their brand.
I think similar thing happened with IO with ChatGPT and the IO hardware IoT company, which has this dispute, and over the night they have to remove all the blogs which mentions the product IO. They got some injection from the court, and ChatGPT had to remove all the references for that IO product because it is sounding like IO. They got the injection and get those stuff removed from the ChatGPT website. Uh, and I have one question. See, in this scenario, for example, take web hash. We don't have any trademark registered in US or some other countries. So we are a startup. We build the product. Today, if someone goes and register the trademark and go and go to the court, and they can claim now the ownership of the domain or do something around it by registering the trademark.
I'm interested in seeing that, in learning what people think about that too.
In my limited understanding of UDRP cases, I've heard that they put this into consideration that whether the domain was registered pre-trademark or post-trademark. However, Todd can explain this more beautifully.
Todd, if you are at liberty to come on stage, please do. And then also Arif, go ahead.
Yeah, I'll let Todd come in if he comes up, but until he comes up, I'll just say, yeah, registration, again, it's not really what matters. It's really usage that matters. Registering it obviously can strengthen it and could clarify, the dates and whatnot. Because if you don't have your trademark registered, then you have to prove, when you started using it in business and whatnot. And again, depending on what you're doing with it, a panelist or a judge might interpret it as a different date and whatnot. But usually it's when you start actively using the brand in the mark in commerce, right? And your registration date is not really as much of a factor. But again, if you go to a court and you say this is my trademark and this is a date, and the person registered it afterwards and your mark was deemed popular enough, then yeah, it does help. If you're doing something big, you should obviously register your mark. But oftentimes people start companies like just here and there, and they grow and grow and grow, and all of a sudden they realize, oh, it goes from a hobby to a business. And at what point do you register it, right? And was it distinctive enough to be registered? That's all these things kind of matter. And again, unfortunately, it's not like the same answer for every domain. It's going to be a little bit different. But yeah, registering helps. But it's certainly, if your argument on the other end, oh well, the domain's not, the trademark's not registered, so it's free reign. No, that's not true at all. There certainly can be rights to a trademark prior to registration. It's just that when you need to enforce it, and sometimes in some jurisdictions they'll ask you to register your mark before you file a UDRP, but that registration, like the date of your mark being yours, can be precede the actual registration date, because in theory it goes back to when you can first prove you've used it in commerce.
Yeah, I think the fascinating part is that trademark is a common law, right? And then it doesn't have to be registered before you can claim it. And then the problem, just like Arif says, sometimes you begin a project with just like a random name, you just want to kick off things, and all of a sudden it becomes very, very big, right? ChatGPT probably is not the best name, but they picked it, and then it becomes like recognizable. People use it. Sometimes people start to use it for other things. And yeah, it's just fascinating to see how the brand rights evolve.
That's actually a really interesting one, because people don't quite understand. Like, I actually think ChatGPT is something that could be trademarked, right? Whereas GPT itself, definitely not. GPT is an industry term. It's descriptive. It's certainly on its own. I don't think could be. Well, I mean, it has. People have tried and it has been trademarkable, at least in some jurisdictions. However, I think that, like, whereas ChatGPT, I think, could be trademarked, in my opinion, I think the opposite. GPT chat is a generic, right? Because it's more of a natural language thing. You can say, oh yeah, GPT, chat is a type of chat. So it's like, sometimes the word order matters. And again, this is my personal opinion. This is a type of thing where I think you ask different people, you'll get different answers. And unfortunately, that also applies to judges and UDRP panelists. It's not always so clear cut. But it's really, you have to know exactly the specifics. What's a generic? How does it apply to the industry itself? Like, Red Apple If you're selling fruit, not trademarkable, but maybe blue apple is, right? Because there's no such thing as blue apples and it's inventive. So it's these weird things and situations that people go, oh, well, no, I didn't know. But yeah, you have to know these things.
Wow, amazing. I think red apple, blue apple is a perfect example because the other case that I want to bring up is some people may know what EVM is. I want to know, like, if raise your hand if you know what EVM is as an acronym. Okay, hit. Not many people, but EVM is like a type of computer, but it's run by Ethereum. It's a standard. And then one of the platform, one of the team that creates an innovative version of EVM called, I think it's one of the three ZK companies. And then one of them want to trademark ZK EVM because they think that's they're creating an innovative thing. But the problem is that it so happens that three companies or more are actually creating zero knowledge EVM at the same time. So in an analogy, Arief just mentioned, like, if it's a blue apple and it so happens that three companies happens to also is creating blue apples, should blue apple at that particular moment be brandable or not?
Yeah, and it depends, right? Did somebody start using commerce clearly before the others, or is it something? Did they call it blue apple because it's a new terminology in the industry? Like, if it's a new terminology in the industry, then chances are it couldn't be trademarked. But if not, if it's just randomness, like they all came up with that name at the same time, it's pretty unlikely, right? So the arguments can be made that there was a reason for it. But again, it's really first to use it in commerce. But even then, it depends on the category, it depends on the strength, it depends on the region, right? Like, you could have a blue apple in Australia, a blue apple company in the United States, and a blue apple company in the United Kingdom, right? And if the product is only, regional, then they all can coexist, right? But if they're all selling stuff on a global scale, well, then there's potential trademark infringements in the different locations. And even worse is that different rules apply in different locations. So that's where things get really, really complex.
Yeah, so complicated. I would be interested to hear about other cases too. So Amit, I think one of the things I learned about you is that you have a lot of domains, right? You have thousands of domains. Have you ever got those things of like, hey, you're infringing me, and then they try to scare you? How do you respond?
Well, first, I'd like to tell you, Victor, most of the people who are sitting here have thousands of domains. And yes, I've got a UDRP case, and it was my mistake. What I did was, when I found out it was my mistake, I sent them a mail, take the domain, because I bought it for $7. I didn't want to fight for it.
Well, that's very nice of you. You just admit your mistake, and then you just don't fight. So how did it resolve? They pay you 700 and at cost, and then you just move on.
I bought it for $7, man. I told them I don't want anything. Just take the domain and stop the UDRP.
Oh, $7. Okay, you hand register it.
Yes.
Okay. Oh, it's lost of opportunity cost, but it's still a great deed you did.
When I realized that I cannot even sell that domain because it was not worth it, that was the best case scenario. The domain was not sellable. I used a company term that was so common that I thought it's a common word.
And it turns out it's a brandable.
Yeah, it turns out it's a brand name, and those people they do it a lot. Like, they were filing 10 to 20 UDRP cases every month. So anybody who uses that terms gives that company an opportunity to send them a UDRP. There was something with the lawyers and the company. Company is a government company, and they hired a agency that regularly does this. There's some kind of arrangement between them. So that was the case. When I realized that, I just submitted the domain, like, take this domain, I don't want it.
It sounds like you actually could protect yourself or defend yourself on a bit, right? If it's a very general term.
It depends on them. They accepted it immediately. Could have not accepted it.
Yeah, that's true. And good news is that our friend Mr. Brett Lewis is on stage now. I think a lot of our fun questions would be able to go there. What was the question that we mentioned that we aren't very sure just now? Brett, hi.
Hi, welcome. Can you hear me?
Loud and clear.
So it wasn't allowing me on because I didn't have a Twitter account, or I deleted my Twitter feed, so it would only allow me to listen anonymously. So my apologies.
No, no worries, no worries. Now that we have you here, that's great because, of course, as you see, if lawyers not in the room, we were just speculating ourselves.
That's what I always say. It's best to just speculate, and probably you don't need a lawyer. And if I leave you with any advice today, that's probably the best advice I could possibly give. I'm joking.
So, Brett, really appreciate that you joined the conversation as a teaser, as a warm up. I think one of our question is that we can begin with a question, and then I'd love to kind of introduce you after you answer the question. So, I think what Amit mentioned is a case where he registered very common terms, and then all of a sudden he get a UDRP because the other side seemed to be very powerful. He didn't know what to do, how to protect. He think he made a mistake himself, and
Right.
he just gave up. What if you were seeing from? I know this is not your case. Obviously, this is not gonna be a legal advice, but in general, how should a domainer treat these letters, and then what's the common things that they should go through?
Sure. So, for better or worse, responding to a UDRP complaint or even a demand letter can be costly depending on who the recipient is, right? So if the recipient is a sophisticated investor who's got a portfolio of thousands of domain names and regularly deals in 5 and 6 and 7 figure transactions, it's not going to be such a big deal for them to get that letter, right? But what if it's somebody who doesn't have a ton of resources? They get a UDRP complaint or demand on a domain name that's maybe not worth that much money. They might have a defense, right? They might have a valid defense to that demand letter, but then they would have to decide whether or not they have the money or the resources to fight back. Which sometimes yes, sometimes no. I recently had somebody contact me who had a good defense, but the domain name they had just adopted, it'll cost them $30 or whatever, and it was going to cost them $6,000 to defend a UDRP claim, right? So in that case, they just decided to move off in a different direction. So the first question is, before you even decide whether or not to respond to that letter and how you're going to respond, depends on, is it valuable enough, and or do you have the resources to defend it? The name itself may not be valuable, but if you yourself, the recipient of the letter, have the resources to fight off overreaching or bullying trademark claims, then you might choose to defend it just because, right? And there are certainly people who do that, but let's say that it's determined that the name is valuable enough to defend. Then the question is really whether or not factually you have a legitimate basis to defend the name, right? And so I ask a number of questions when a client contacts me about, first, obviously, what is the domain name? When did they acquire it? When was the trademark in question first used? There are geographical questions about where parties exist. It may be that you have a trademark holder in Brazil or a trademark holder in France or Denmark, all situations that I have had. And they are asserting claims against the domain name and the registrants in the US. And while the registrant has never heard of their Danish trademark, right, for a windmill company, or they've never heard of their Brazilian fashion brand or whatever it ends up being. So it's critical first to get the facts. I'm going to talk a lot here. You can stop me from talking whenever you want me to, like whenever you want to interject, feel free to interject. But also, let's say common dictionary word is a very good start in terms of whether you have something which is defensible or not. But I think I heard red apple, blue apple when I was trying to log in before, and it was anonymous. The word apple in and of itself is a dictionary word. It's also the meaning in English language is for a particular type of fruit that grows on a particular type of tree, right? Of course, we know that there's Apple computers, and they make a series of devices and products and television shows but then there's also Apple surgical gloves and Apple Bank and a bunch of other uses of the word Apple that are used in trademark contexts. So Apple could be fair game for someone to use, like maybe I want to introduce I want to open up a bobblehead company and I want to call it Apple. Well, I would have to do a trademark search in order to determine whether there were any companies out there that were selling bobblehead dolls under the name Apple or something confusingly similar, right? And then that might be legitimate. Let's say there aren't. I have a clear path to using the word Apple. But if I register Apple and say, oh, it's a dictionary word, but my intention is to sell it to Apple, the behemoth, the 800-pound gorilla company, or even Apple Bank, then that's improper. So why I think the domain name area is so interesting and at the same time such a difficult area for people that invest in domain names sometimes is because the answer to whether or not the registration of a domain name is valid or in good faith or in compliance with the law depends upon the intent, the unwritten, unknown intent of the person who's registering that domain name. And so, I had a situation where a client registered a domain name, which is a surname, but it was also one letter off from a very, very, very famous company's trademark. And so were they registering the domain name because it was a surname, or did they register it because it was a typo for a very, very, very famous company's trademark? Right. And that is a factual question. If this goes before a judge or if it goes before a UDRP panelist, they have to crawl inside the head of the person who registered that domain name, and they've got to try to figure out as best they can what they think the intent of that person was at the time they registered the domain. So that's a kind of far-ranging answer to maybe a start of an answer to the question that you asked.
Thank you very much. Thanks for a natural warm up. And then, of course, I love the other guests on the stage to kind of have an interaction, ask question about Brett. But first, let me share my deep admiration and respect for Brett Lewis and his team by getting a chance to introduce him. Brett E. Lewis, an industry-leading attorney in the world of domain laws, dedicated himself since the very, very beginning of domain time, I think. He practiced and his team practiced domain laws, trademarks, copyrights, internet litigations. He's the founding partner of Lewis Lin LLC, a Brooklyn-based boutique law firm that's become a go-to name in high-stake domain disputes and digital IP enforcement. They established it since 2011 and has carved out a niche specializing in internet law, UDRP complaints and defense, cyber squatting litigation, ACPA, and trademark strategy. So specifically, I think we found out that Brett Lewis and his team practiced before U.S. federal law courts, USPTO, WIPO, and NF, all the venues that you can think of to protect your trademark and domains. So, and he has played both the defense and offense side, and have done very successful and great cases for their clients. And it's just a very valuable thing for us to have in our community. That you're here, and I really appreciate that you're here today, Brett.
Oh, it's very, very flattered to have been asked to speak to anyone about this stuff. So I hope that I can provide some information to people to help them to understand some of their rights better.
Yeah, so Brett, I think one thing that would naturally be a good starting questions is how you started, because of course, as an OG, you started as almost the same time when domain started, right? So I think people probably didn't think of domain as a right, or maybe they don't necessarily think of it connecting to trademark. So can you talk us through your career and maybe some of the interesting case you went through, how this industry was shaped, how you become a lawyer in the space?
So I did start pretty close to the beginning. It wasn't the absolute beginning. when I got out of law school, I went and I clerked for a federal judge in the Eastern District of New York. I had already spent a summer working at a big Wall Street law firm, and I knew I wanted to do litigation. I didn't really realize at that point that I wanted to be an internet lawyer or a domain name attorney. I came back, and it was really just a confluence of factors. I kind of stumbled into the practice area almost happenstance. I very, very fortunate because I think it's a great, very interesting field to be involved in and to have practiced in. But I mostly wanted to work with a particular partner at the law firm that I was at. She is a terrific lawyer, and later was voted, like, I think, lawyer of the year by the New York City Bar Association a few years ago. So she is a very well-regarded, prominent attorney and just a fantastic overall person, Susan Coleman. And so I joined the IP group at Winthrop Simpson in order to practice with Susan. And it just so happened that the year was 1999, and the new laws were just being written. The Anti-Cybersquatting Consumer Protection Act went into effect in 1999, as did the UDRP. And so literally no one at this 150 or 60-year-old law firm in New York City knew anything about domain names or how to do any of this. And so I got a case, and then I got another one and another one, or a dispute, and then a litigation, and became kind of the go-to associate at the firm for this kind of thing. And what really changed the trajectory, I think, of my career, because I think a lot of lawyers who practice at big firms develop this sort of big firm mentality where they think that everyone who is a big corporation who has a trademark is in the right, and everyone else who owns a domain name that they want is in the wrong, right? And it's a very kind of myopic view, and there's a lot of bias that goes into it. And I had a client, the firm had a client who was a domain name investor, and it was back in the .com boom, and firms were trying to, get a piece of that money, I think, in that business. And so they had him in, and he was working on a business venture, and they're trying to raise money for something, but he also had a portfolio of domain names, and issues would come up. And so I got an education in defending against those kinds of claims. And it was really, really formative and interesting because I got to see the law in a very different light. And then when I was ready to make a move, I applied for a job at register.com. And even though apparently I submitted my resume like right at the end and they were ready to hire somebody else, I came in and was like a dark horse candidate, they told me, and they hired me in part because my perspective on what constituted cyber squatting and what were legitimate rights into a domain name were different than any other attorney that they had interviewed, right? I saw things in a much more open way, and I saw the side of the respondent in a way that these other attorneys didn't see. And so I spent 3 years at register.com, which were also very interested and informative. And then I left to start my own law firm. And then eventually, maybe 6 years later, partnered with David Lin. And then that was the start of Lewis Lin.
Amazing. Just for people's context, I know there's a lot of audience, OG in the audience. So you may already know, but register.com is one of the first 5 testbed registrar to launch and compete in the domain registration space. And it was the time when Network Solution is in monopoly. ICANN was establishing its authority, and then probably all the UDRPs were still like forming itself. And then you joined the register.com, one of the early pilots, and then you were on the defending side. Like, I think a lot of people, just like what Amit says, anyone who are in the space probably owns hundreds, if not thousands, of domains, and every once in a while, issues and letters and complaints like that just come up, right? They definitely need someone who is on the defend mind and can tell them what rights they own, what things they what if they do can protect their domains to be taken away from. So you started out as a defense lawyer. Like what are a few interesting case that you've seen and then that you defended successfully?
It's an interesting question. So if you think about UDRPs, what's interesting is there have been sometimes clients who have defended themselves in a UDRP process and lost and then come to us. And I have had the experience of looking at the papers that they filed, and clients don't often know what arguments are valid to make and which ones are not. And so they may make the wrong arguments or not put other evidence in front of a panel that is important. Like, this is not really a secret. I think some of my colleagues and competitors, if I want to call them that, like Esquire or John Berryhill, would know this. But if someone's accused of registering a particular name and targeting a trademark holder, one of the things we do is ask if they have any other similar names in their portfolio, or if they registered any other domain names on the same time or on the same date that they registered the one that's being disputed. Because if someone has an interest in a particular root or form of a domain name, and you can prove that by showing they've registered other names that could be the word sync, or it could be value, VALU, or it could be, if they have a history of registering that kind of domain name, then yes, it tends to illustrate that they're not targeting the trademark holder. Maybe they like registering domain names of animals, maybe that's their thing. Or geolocations, and the name happens to be the name of a city, but it's also the name of a pool supply company in New Jersey. I had that case. So you try to find evidence or develop information that would support that the client's intent was other than to target the trademark holder.
Yeah, I think that's a very good explanations and help a lot of our domainers understand that they could have the rights if the claimed trademark owner actually doesn't monopolize the name, right?
Yeah, and this is the other thing. There are many situations. So if you're talking about a famous trademark, and people misapply this terminology a lot, but a famous trademark is a thing. There is a level of notoriety where a name is a household name, and like Google is a famous trademark. It's a household name. Microsoft. I cannot, if I want to sell my own line of jeans, right? Clothing, jeans, and I want to call them Microsoft because I'm going to use Microsoft fibers in my jeans, and I want to call them Microsoft jeans. I cannot do that. And the reason I cannot do that, it's not for trademark infringement, it's for trademark dilution. It's that the trade, in a sense of a famous trademark, it becomes, the mark is valuable in and of itself because it is the only trademark of its kind. No one else uses it, right? No one else can use it. If someone else were to start selling Microsoft jeans or Microsoft, I don't know, lemonade, it would take away from the unique, all-encompassing power that trademark has to identify the goods of a single company. So if you're dealing with a famous trademark, you cannot ever register the domain name of that trademark and say, oh, but I was going to use it for something else. You just can't. But for anything else, for dictionary word domain names, or even some pretty well names like Delta is another name that comes up in examples, right? Delta is a geographical term, right? It refers to a particular type of geography. A delta, I think it's a Greek letter. It also is used by an airline and a faucet company and Delta Dental. There are many different companies. Delta's fair game as long as you're not targeting a trademark holder with it. Now, caveat, if you it's likely that any domain name, which is a dictionary word, which is also, the name of a big corporation, is probably already registered or in use by someone at this point. But caveat, if one were to go say, okay, I want to register delta.xyz, it's probably already taken. But if I want to do that, sure, it could be valid, but you've got to be very super careful that you don't, that you can explain your intent in registering it and that you weren't trying to target a trademark holder. And so there is that, idea that it is wide open. Like trademarks are typically, domain names are available, but you have to be able to have a legitimate reason for why you register them almost. And then if you register certain domain names, know that you would have a higher likelihood of inviting a some kind of, whether it's a letter or a UDRP or an action in court, like whether or not your intention was to squat on a trademark holder. There's that whole other side of it where they just want that term.
Yeah, that's right. Like I think you can defend a domain there's many factors playing in it, and that's why you need a great lawyer, right, to help you think about any defense that you can have for holding that domain. I like to also say the next question for me to ask, and after that, I want to open up the floor because we want to have a town hall and everyone can ask our distinguished guests the question because they probably have the question in their mind for a while. My question for you, Brett, before opening up the floor is, what are a few common mistakes domainers can make that lose their defense, like that make it harder to defend their domain holding? And then people should kind of be very cautious when they act upon that.
Parking the name indiscriminately so that it monetizes. The pay-per-click is optimized to return the greatest financial return. This may be a strategy that works for some people because if they're dealing in high volumes of domain names and they only get so many disputes, they feel that it's worthwhile. Or if they've offshored their business, they don't feel like they're at risk of the more serious consequences of being sued under the ACPA. But I have seen domain names that are absolutely defensible. 100%. I could win 100 out of 100 times defending them, but the client has put them to park them, and they monetize park page ads that are competitive with the trademark holder, and that's it. It's the end of the story. It's pretty much over. Every once in a while we can defend one of those based on the facts. I mean, in a UDRP, they're supposed to prove registration and use in bad faith. So sometimes there's a timing element there that we can argue that the name wasn't registered in bad faith if enough time went by before the name was parked. But parking is probably number one on the list. Another one would be contacting a party and offering to sell them the domain name, a party who's a trademark holder.
Oh, why?
It depends. Well, if they're a trademark holder, I'm looking at Hippeas, HIPPEAS. Okay, I eat these things. Don't ask what they are. You can Google them. It's a snack. If it's supposed to be a healthy snack, who knows? If you register Hippeas, HIPPEAS.com, first of all, it's pretty distinctive, right? So chances are you are targeting these people. But then you pick up a phone or you email them, like, hey, I own Hippeas.com. You want to buy it? Like, you're showing that your intent in registering the domain name was to profit off of their trademark, even if it wasn't. So now, let's say you reach out to, it's not Hippeas, but it's something a little more common, like Blackwell. And there are 30 different companies or 50 different companies that use the word Blackwell in their names, okay? And maybe Blackwell is also a surname. And you reach out to 30 of them. One of those Blackwells might sue you. Maybe multiple of those Blackwells might sue you if they're trademark holders. However, you have a better defense at that point in time because you could say there are 50 Blackwell companies and I wasn't targeting them specifically. I reached out to 50 different ones who are using this and no one has exclusive rights to it. But that act of reaching out to someone and making an offer in so doing, and not knowing what the factual context is of a particular situation, but in the act of reaching out to someone, you are taking the chance that that person is going to respond negatively. I actually have that case right now. We're defending dirtyharry.com. And I don't want to make a bad pun, or a bad joke, but it's almost like the client reached out and sent he did that. He sent solicit like emails to maybe 20 or 30 different potential buyers who were using Dirty Harry in their business names. But one of the people that he sent it to was, I believe, was Paramount or Warner Brothers, or no, I think it was Clint Eastwood. So he sent an inquiry to Clint Eastwood. Clint Eastwood told Warner Brothers. Warner Brothers filed the UDRP. Dirty Harry has taken on connotations. It started off as its own thing in the name of a movie franchise from the early 1970s through the 1980s, but it also it's a term that's entered the vernacular. So did the client have a right to reach out and try to sell the name? I believe that he did, but is there a risk in approaching Clint Eastwood and saying, you want to go ahead, make my day punk, you want to go ahead, you want to buy this domain name? Well, do you? It's like, there's a risk. So I'm not saying that he did anything wrong per se, didn't do anything legally wrong, although a panel will decide what they think of it. But it was an action that provoked a response. Does that make sense?
Wow. So make sure that parking is one of the problem, and then reaching out in the wrong way is the problem too.
Yes.
Yeah, because we were discussing whether our domainers will do outreach. And by the way, anyone on the stage, feel free to chime in now if you have questions. And I'm gonna continue to ask if no one yet raise your hand or jump in to ask questions. Oh, Ira, are you unmuting yourself?
Yeah, I had a question of, the way you were saying about Delta. If somebody does something with Olympic, I know they dramatically guard their mark.
Yes.
So there's 5 or so grandfathered Olympic or Olympia marks that are legit, but nobody else can get in there, at least so I'm told. Is that the fact?
Yeah, and Olympic actually has an extra level of protection because the Olympics actually, in their contracts with different countries, they stipulate that for all Olympics going forward, that their brand have not just regular trademark, but there's actually some kind of contractual thing with the countries that stipulate that you people can't use that unless it's grandfathered. Like I think in the United States, there's a region in near Seattle called the Olympic region or something like that because of one of the mountains or something like that. And it existed before you could continue to use it, but otherwise, any new company can't.
Yeah, well, I'm glad I gave Summer Olympics back to them.
Yes.
I actually contacted their legal department and I tried to trade them for tickets to the Summer Olympics. That didn't go well, but they sent me a box full of Olympic junk and said, thank you very much. We really appreciate it. But I couldn't believe it got out in the wild.
Right. Oh, Ira, is that you?
Yeah.
Oh,
you remember that? The long time
I remember you. We met years ago, and I remember you. Who's that picture of? I don't want to.
I think John coined that when with Success Bank. They tried to go ahead and they started a bank, and I registered it 4 years prior when another one went out of business. So 4 years later, they tried to UDRP me, saying I registered it to go ahead and blackmail them. And John said I must be a psychic cyber spotter now.
I actually, what I used to call it was the Dionne Warwick Psychic Friends Network defense. Or not defense, but complaint. The Dionne Warwick Psychic Friends hotline complaint. So John and I were
so if they want it, it's going to cost them some big money at this point.
Yeah, I think John and I may have had a psychic connection on that one as well.
Yeah, it was pretty funny at the time. But, I was pissed that it cost me whatever, $4,000 to go ahead and defend it because there was nothing there.
Well, that's always I don't want to divert this too long, but that's always the thing, right? If you're in the business of investing in domain names, and then somebody wants one of your names and they file something, then it becomes it's a cost to you. But it's almost like anyone who enters this business has to know that that is likely to happen at some point in time. And almost the better the names that you have, the more likely that that is to occur. Either if you have a very, very dirty portfolio of trademark infringing names and typo squat names, you are highly likely to find yourself on receiving end of disputes. But also if you have a portfolio of very, very good names that people want, you will find it happening. I had a call this morning from an existing client who was asking about filing a UDRP complaint. And, what does he know? He called me up and he said, they're squatting on the name. They want $37,000 for it. These people are squatting on my name. It's his last name. It's an unusual last name, but it's his last name. It's also a business name. But he's only been in that business for 3 years, and this name has been registered since long before that. He inquired about purchasing the name. They gave him a price that he didn't like. If he went ahead and filed that, that's a Plan B UDRP complaint, likely reverse domain name hijacking decision. And there are lots of lawyers who are happy to take that money and file those things. And so for you, like taking this back for full circle, you almost can't avoid that happening if you have good domain names, but you've hopefully you're doing well enough in your business that it just becomes a cost of doing business. And then when you beat them in the UDRP, that enough of them have to come back and eat crow and actually pay a legitimate price for the name.
Yeah. Brett, I think you mentioned a word that I just recently learned, reverse domain name hijacking. It's actually a term that where a domainer can actually turn from a defense side to the offense side. Can you, I assume most of the OG already know that word, and whether they have used that in defending themselves and even turn it into offense, I'm not sure. But maybe other newer domainers will benefit from you in explaining this term. And what are common cases you can make a case that it gives you the chance to argue for reverse domain name hijacking?
So within the context of the UDRP, reverse domain name hijacking is kind of like being slapped on the wrist with a wet noodle. It's no real sanction, right? The only thing that it does, it should provide a degree of embarrassment. It doesn't necessarily stop everyone who should be embarrassed from going ahead and filing more complaints that they should never have filed in the first place, right? And I can't remember which one it was, but I recently defended a domain name where the party that filed the complaint against us had filed a similar complaint against another party and had gotten a reverse domain name hijacking finding for doing it, and then went ahead and just filed another one. So there's really no consequence in UDRP context. There is a provision of the Anti-Cyber Squatting Consumer Protection Act. It provides for a cause of action for reverse domain name hijacking. It is a very, very specific and set of circumstances where somebody has to have lost their domain name in a UDRP dispute where the complainant misrepresented facts concerning their trademark rights. And the panel relied on the misrepresentations of fact concerning their trademark rights in order to issue their ruling. It is a much narrower set of facts than the RDNH and the UDRP. I'm trying to remember what you can get as far as damages. I think the argument is probably attorney's fees. And I know John Berryhill's made the argument for up to $100,000 in statutory damages. It's not clear to me that the statute actually does provide for statutory damages.
Interesting.
Isn't that a civil case?
Yeah, I think maybe it will have additional circumstances. I think Todd has his hand here, and Todd is someone I really respect, who served the community very well with his Twitter space regularly held about domain laws. And Todd, thanks you for being here.
Well, it's wonderful to hear from Brett, but I'm going to have to pass to Namer Tips because he was here before me. But Brett, I think you're probably talking about your beach jet case because I think that was the one where they, the place Textron files against everybody, and they have been, ruled to be a reverse domain name hijacker. But anyway, I'll come up next. I got to give it to Namer Tips. Him and I see, some others been here longer than me. So go ahead, Namer Tips.
It probably was BeachJet, and I had like 5 UDRPs going last month or whenever that was, so I couldn't remember which one it was, but thank you for clarifying that for.
Cool. Go ahead. Namer Tips. We couldn't hear you.
Yeah, he's going to have to leave and come back. Hey, Brett, it is wonderful to speak to you. Reason I did, so I'm not going to promote my show. Comes on in 2 hours from now. I do it with Jeff Newman. It's called Domain Name Law. And when I first started doing it like 5 years ago, Brett, even Zach Muscovich, a bunch of lawyers, and now of course I'm friends with most of them, except sometimes I'm not nice to all the lawyers. I really love your attitude, and I can't wait to have you a guest on that show. But anyway, so I do it with Jeff Newman and David Michaels. But of course, we've had John and all your I really miss Howard New. I know you know them all, and of course Ari's not doing it much anymore. But I know you've seen the industry grow. Especially a lot of you guys have really helped develop out the aftermarket by representing domain owners. But so I wanted to say one. Just in these last 2 weeks. So what we do, we review UDRP decisions like recent ones. And that's how I knew BeachJet because we reviewed it last week and I didn't even know. We actually said some nice things about you probably. Now the week before, Brett, I probably wasn't so nice to you on this value max. When you were representing the complainant in value max. Lucky, I would say lucky for your client. You probably could have kicked some ass either way. But for your client, lucky that Don Osborne was the panelist there, notoriously on the side of the complainants. But that case I won't get to, but I really thought you presented a good case there. But Value Max is used by so many different companies, and it ended up being transferred to your client, which was, I love when you effectuate a positive outcome, as you lawyers would say. But you did a great job there, especially for a name like Value Max that has, across a lot of industries. But I wanted to ask you, so enough with my horse hockey. When you were talking about the PPC landers, and Jeff Newman, who's a partner of mine, and also co-host on the show I do, he has always been frustrated with these registrars who, you register a name, you don't do anything with it yet because, we're regular business people. Sometimes it takes Disney 10 years to make a movie. It takes a lot of big companies a long time to develop out domain names. Sometimes we'll register a name for a business. It's got these PPC links that are provided by the registrar, yet we're in trouble for it. So how do you, if it's PPC links that are provided by the registrar, what responsibility does the domain owner have to, in some cases, some panelists say they have all the responsibility, but how do you defend against that when it's the registrar who's put up these PPC links? Go ahead.
Yeah, I think that's ridiculous. So I want to say one thing. I have a philosophy, or I don't know if it's a philosophy. It's certainly my understanding of what is legitimate or valid registration of a domain name doesn't change based on who I'm representing. So, or it does not change, I would say, very much. I am not going to make an argument that passively holding a domain name is cyber squatting. It's just so I can win a complaint and then turn around and come back and say, no. Passive holding, not by itself. What are you kidding? No, that's not cyber squatting. So there are, I would say the Value Max situation based on the PPC links to my client's product. That's what greenlit that for me, right? In terms of filing it. The fact, and I said, having PPC links up to competing products is probably the biggest thing that I see that's problematic for people. If there were not PPC links to my client's products on that site, I would never have taken that on, right? Because for the reasons you say, Value Max is a fairly common term. But then if someone registers the domain name and they're monetizing it against a particular trademark holder, then that creates the difference there. In terms of getting back more specifically your question about registrars, I was at register.com when they and others started doing that, putting up the park pages and then monetizing them. And I think it is a really, I was going to use a vulgarity, but I am not in favor of that practice. I think because they are monetizing whatever domain names are registered through them, right? And so there are going to be a number of trademark names that get registered, or there'll be ambiguous names that aren't necessarily targeting a trademark, but they are also trademarked or in use as trademarks. And so when the registrars monetize those domain names, they're making money potentially off of trademark infringement, but they're also, like, if they're optimizing, they don't care whether or not they're infringing, but then they're throwing risk onto the domain name investors or the domain name holders, their own clients. So their customers. So I think it's absolutely ludicrous that there are panelists who will blame the registrant for that and say, oh yeah, but you registered this domain name with GoDaddy, so you knew, or you benefited because they charged you a lower price because they were making money off of monetizing that name. I think that is absolutely ridiculous. I certainly hope that's not the majority view. But in terms of what you do about it, I mean, you have to, when you register a domain name, you've got to then point the DNS to nothing or opt out of being in that, having your name parked with the registrar. I do agree. I don't like it. I don't like that practice. I never liked it.
Thank you, Brett. And I like calling you Brett over and over again. You know how to. Victor's fantastic to have you. But Victor, leave the room. He's in on this a listener now. But I say fantastic to have you as a guest. And we have like 3 or 4 guests per year. Have all your friends that you've known. You've already mentioned a few of them here. But also, hopefully, maybe you stop down there at NamesCon, because we were doing some panels there. I'm doing a couple with all the lawyers. I'm the only one that's not a lawyer. I went to law school, but they wouldn't. It was because I took a wrong turn and started law school. But I never did pass the bar because anyway, stopped at a bar along the way. I'm doing some great panels with some lawyers. And if I knew you were going to be at NamesCon, certainly almost like to have you join us, because anyway, you mentioned a couple things that John always says. That's Barry Hill. And also, my 2 co-hosts, Jeff Newman and David Michaels, if I can name drop. Mm-hmm. You mentioned going, when it comes to reaching out, you can, if there's numerous folks that are using a mark, reach out to numerous. So I'm telling this to the domain investors, right, to show that we've reached out to 20 potential people that could use this mark. As soon as you start targeting, even if it is a common term, you can get in trouble, because we get people like, this is generic. So it's pretty descriptive of a term. So I bought it and I contacted this one company, and they're really targeting. So you can still be caught up in targeting, like you mentioned. I'm glad you did, about, you might think you have a safe name because it's descriptive or generic, but you still can't intentionally target someone. So domain investors, sometimes think they can do that. By the way, one other question, you can help me with my show today. We're going to be talking about registering somebody's personal names. So what type of problems do people get into when they register someone's personal name as a domain name?
So there is a section of the ACPA, the Anti-Cyber Squatting Consumer Protection Act, which says that it is cyber squatting to register a person's personal name with the bad faith intent to profit by selling it to them. So if I registered Jane Smith, for example, or Joe Jones, that's okay, as long as I don't have a particular person in mind. It's not like, maybe there are 1,000 Jane Smiths out there. It's not like I'm targeting one of them. But, I had a situation where somebody registered, I guess I could talk about this, Harj Tagger. He is one of the principals of Y Combinator, right? It's a very distinctive name. And they put up some weird website with some I think some monetized links on it or something. And so, yeah, that runs afoul of the ACPA, right? Because they're targeting a very specific person's name and what's their intention in doing it. I mean, I suppose if you registered a known individual's name without an intention to sell it to them, and you could prove that you weren't intending to sell it to them somehow, then you wouldn't be technically running afoul of the ACPA. But anytime that anyone registers an individual's name, and it doesn't have to be a trademarked name, it can just be their individual name with a bad faith intent to profit by selling it to them, it violates the ACPA.
Thanks again. And I always say that, Brad, that right, they have the standing. If they don't have to have a trademark. If it's their personal name, their legal name, they have standing to file an ACPA action against you. And you were right earlier. It can be $100,000 and some attorney fees. Of course, the attorney's got to ask for those fees, but usually it's not. But I'll be bringing up later today that I did Yao Ming sued me for $100,000 in one of the first ACPA cases for a domain name, and we won. But yeah, that's where it gets a little, scary for a domain investor. You own a name, and it's much nicer to get a UDRP complaint because you really can only lose the name. You
Correct.
can't have these penalties. But hey, thanks for spending your time here today with a lot of us. We appreciate it and look forward to talking to you in the future.
Absolutely. It's a pleasure to speak with you and Victor and everyone else and Ira.
Yeah, thanks so much, Brett. It's very nice to have you. If there's one takeaway that you want the audience to bring back, especially if they're a domainer, what would be that line that they should take away from today's conversation?
Oh boy, one line.
Or a few.
I don't know. I think it's just be aware of what they're doing. Be conscious if they're registering dictionary word domain names. Try not to do something silly look, it's not always silly. I know of people that do it on purpose, that will register names that are typos or that are right up against the line or over the line because they want to maximize the pay-per-click revenue by trading off the goodwill of trademarks, right? And I'm actually not here to condemn and or not condemn that behavior. But if you're not looking to invite potential lawsuits and you're not in a position to defend yourself, then just be mindful of how you're using your domain names, right? There's so many different ways that people get attacked by trademark holders. Oh, you're passively holding the name. That's bad faith. You only used it for a little while. I've heard, which is a terrible kind of but it is the monetizing domain names for PPC indiscriminately can really get people in trouble, and gotta have an awareness of how your names are being used, especially of good domain names that are dictionary word domains or they're brandable domain names. But I want to add to this, though, take a slight pivot. If you registered your domain name before the trademark holder ever came into existence, it becomes a different issue. You don't have a worry as far as cyberspawning is concerned, but you could have a worry as far as trademark infringement is concerned. And PPC that targets a known trademark it won't cost you the domain name necessarily if you can afford to defend yourself, but it could still be considered a use in commerce of a trademark which is infringing, right? So you just got to be real careful with that. That would probably be the biggest cautionary tale.
Thank you very much, Brett. Thank you for being with us. And then we look forward for more conversation like this. Domaining is definitely a journey. And then in it, you'll see you had adventures. I hope everyone enjoy it, and then everyone should pay attention to laws. And then when you are in question, go find a good lawyer, like Lewis and Lin and Brett's team. And everyone, thank you very much for our conversation today. We appreciate Arif, Amit, Todd, Ira, Domain Insider, and then Paul Singh, who just got on stage. And also really, really appreciate our featured guest, Brett Lewis, for our domains dispute and due diligence. Thank you very much. See you next Twitter Namefi space.
Thank you again for having me.
Thank you, Brett.
Yep, we'll keep the room open for a little while for everyone who want to have an after chat, and also for everyone who want to follow people around. And all these are great guests. So please feel free to chat after chat and also follow each other. And Paul, glad to see you here.
Man, did I just miss Brett? Did he leave already?
Yeah, he left. He was here for the full hour. And
I
then
know.
what
I was
question
just
do you
sitting-
have?
Well, I was sitting listening to the whole thing. It was so informative, like kind of a breath of fresh air in the just domain space to hear about all this. My question was, he kept mentioning pay-per-click, and I wanted to find out more about, like, what about an affiliate model? If we have direct relationships through an affiliate network with the affiliate and we place them, does that offer us some additional protection? Or how about a secondary part of it where we ourselves are the affiliate network? We ourselves, are the middleman and we are doing the pay-per-click. So does that offer any kind of protection where the advertiser has actually approved this type of advertisement on the site? That's kind of my angle I was trying to get at, because he mentioned pay-per-click a lot. And I get that. I mean, I get where he's coming from, but that'd be more through like a network like GoDaddy where they have a landing page. But my question was more along the lines of, how about if you have more of a direct relationship with the advertiser through a network, does that help at all? Yeah, so that's where kind of what I wanted to really ask him, but got on stage too late. Thanks for the space here, and very informative.
Thank you so much, Paul. On one hand, that's an amazing question. I will pass it on to Brett. I also want to mention Todd, our good friend, and his two other guests are having another space really soon. So you could have just asked that same question. I think what's special about Brett himself is that he specialized not just in general UDRP. I think among other lawyers we have talked to, his firm took a lot more in defense side. So I think he would give a really good answer as well. And also, David, thanks for joining the stage.
Hi. Yeah, so Paul, I have an answer for you. Look at the affiliate program terms and conditions. Very often, especially the ones that are listed on CJ and other affiliate networks, they specifically prohibit you from using domain names that match their trademarks, the advertiser's trademarks. So, yeah, you have to check that first. Now, if you are an actual dealer for them, that's a different story. So, like, for example, I'm an UMA dealer and I have an UMA domain name. So I have a right to use it and develop it and get customers and funnel them all to UMA. So that is that's like an OK data test, whether you're authorized or unauthorized. But there has to be something in terms of conditions that would prohibit it for you to have some worries about it.
Yeah, no, it makes sense completely. My thing was more along like most of my names are just generic, just generic dictionary words, business defining, category defining, and so forth. So don't really touch anything trademark related. But even so, I've still had an INDRP for the Indian word for cars, for example, because the counterpart, the .com, was already developed. So that's kind of one thing. And, I went through this route where I had an affiliate relationship with that company through an affiliate network. And still, I lost the domain through the INDRP. But I'm thinking maybe if we go another route where we have a direct relationship to the advertiser, either through an affiliate network that we've developed ourselves, does that help at all? Yeah. So that's, where I'm getting at, where you set up let's just say you have an affiliate network and then you set up the affiliate relationship through there. How can you get a UDRP at that point is my question, where it's like everything, you're controlling the entire process from advertiser to listing to advertisement on your site and getting the approvals and all that. So yeah, anyway.
Oftentimes where people run into problems is if like you are, as Todd said, oftentimes you are allowed, or was it Todd? Somebody mentioned that you are allowed to use certain marks in certain conditions. What will really get you in trouble is if you're not representing that brand exclusively, right? Like if you're a Firestone dealer, right, for the tires, but on your site that contains the mark Firestone, you're also trying to sell Goodyear tires, that's really going to get you into trouble. Some cases you might be allowed, you might be not to. In some cases, it'll be within the contracts, right? But the contracts won't really apply to a UDRP, right? It's whether you're infringing or not in the UDRP, but a contract can still get you into trouble legally, right? If you represent them as an affiliate. and they tell you can't use it, well, they can obviously break the affiliate agreement at any time, which probably makes the domain, valueless either way. And then, yeah, you just got to be careful you're not doing anything else on that website.
Are you guys familiar with the opportunities tab in CJ? There's a section in CJ called opportunities where you're able to list kind of your domain names, whatever you have, and you'll find advertisers that'll reach out to you that are interested in that domain name. So I'm wondering if that itself right there, it's like you're listing out your domain name. The advertiser is reaching out to you, letting you know they're interested in advertising in your name. So, what I'm trying to get at is the protection part. What is the best way to protect our names with, we want to stay, we want to stay above the thing. There's no trademark, nothing like that. I don't get involved in it. I'm talking about generic words, even just overall protection. Does that offer a protection? Like the opportunity, I don't know if you guys have messed with that. I'm sure maybe David, you mentioned CJ, maybe you've seen the opportunities section in CJ, I think.
Yeah, they're not going to go after your generic terms. If you're selling shampoos and you got shampoo.in or whatever, that's not going to be a problem. You're never going to lose that.
You'll be surprised if there is a counter. With the INDRP is different than the UDRP, so some of the rules are a little bit different. So just overall protections, is that something that you're familiar with? The opportunities.
Yeah. So the other way to do it, even if there's a close case or not a close case, is just have written in your contract by joining your affiliate network, they forego all claims and they have no ownership in your domain name and your website. They have strict terms of access to it. And if they don't pay the commissions, they're out. They have no right to ownership of the website or domain name in any way, shape, or form, that type of thing. Contractually,
That's what I was trying to get at. That's something I would set up on my own network, put in all those terms and conditions that you mentioned. I think that would be the best way to go about setting up these relationships and possibly finding an advertiser or a buyer for your name going down the advertising route. But yeah.
Yeah, because you have generics and it doesn't matter. Look, what I was talking about before is like, if using like Goodyear or Firestone, right? Then it's like
that's
a specific brand. That's what you got to be careful of. But if you have tires.com, then you're safe either way. Now, again, with the caveat being, country codes are a different beast, right? Every country has their own rules, and they might make sense, and they might not make sense, and they could change at any time, right? So you got to be careful with CCTLDs because the rules certainly are different, and how they get applied are different. And you could have a country where it's some dictator's brother who's in charge of the extension, right? And he just wants to get that domain because he wants to give his friend a business because the friend's going to give him $5,000, right? And that's within their right to do so, right? You might fight back if their laws are certain laws, but if it's a country where there's laws are a little bit more, a little bit less sort of enforced, well, then it's just too bad, so sad, right? That's CCTLDs are dangerous that way. Usually it's okay, but there is that risk.
Yeah, Namer Tips have their hands up for a while. Namer's Tips, do you have something to add to this conversation, or are you starting a new one?
Definitely. To this conversation. Can everybody hear me?
Yeah, loud and clear this time.
Perfect. I hated that I missed Brett because he was hitting on some key points. This is a great conversation to be had, and I think that a lot of domainers, true domainers, the ones that really take it seriously, this needs to be a part of their starter course. I want to go ahead and add some value in the sense that, on this side, we've gone through some UDRPs and have successfully won them. But in that process, we've learned a lot about WIPO's relationship with corporations and ICANN's alignment with WIPO and that whole thing right there. I want to bring something to everyone's attention. I think it was Arif. Please pardon me if I'm, butchering your name. But he brought up a very good point about the CCTLDs and some of the inherent, risks that come along with registering those names and even trying to sell them and so on and so forth. But there's another thing to look at, which are more of the generic TLDs. Think about your .car, your .health, and things of that nature. There are a lot of companies that are waking up to the fact that those TLDs are available, and some of them are feeling a certain way about having certain names in their portfolios. But I want to bring something to your attention about the fact that when you are dealing with the UDRP, something to take into consideration is the fact that a lot of these corporations have access to a sunrise period, right? The sunrise period, for anyone who's not familiar with it, is a period where the registries allot a particular time for trademark holders to go and petition for their names under a certain extension. If you look at certain domains or certain TODs, you'll notice that they've been around for a while, right? Many of them just haven't had the traction. But if you end up in a UDRP with a particular company and you're not using the domain in a malicious way, if you end up in a UDRP, one of the things that you might want to go ahead and consider looking into is that they take advantage of the sunrise period, right? Because a lot of these big corporations that are making millions upon millions of dollars and they have these extensive, legal teams, for them not to be taking advantage of the sunrise periods for these names is rather irresponsible, and it kind of leans into a sense of entitlement. So if you have a name and you intend to use it, I think that it's important for you to make it clear what you're using it for. If you have any IP, align the name with your IP and make it clear that you're doing so. In addition to that, make sure that you note when the UDRP sunrise period came about for a particular TOD. It does not guarantee that you're going to win any UDRP dispute. And I just want to make this very clear for anyone who's thinking that the UDRP processes are just wham, bam, thank you, ma'am, and done. No, they can be long, right? They can be very extended, people taking their time to get back and all of this other stuff. And then on top of that, I don't know if anyone mentioned it here, but when the UDRP is going on, the registrar locks the domain. So anything that you want to do with regard to selling it, transferring it out, and all of that other stuff, it's halted until a determination is made. I would also encourage for you to go ahead and conduct research on whoever the presiding determining lawyers or any individuals that are representing WIPO or whatever, or who are making a determination on the case. Look into their background, right? We want to believe that all of this is 100% ironclad and nobody has interest, but there are people who talk on the back end. They send emails, they ask questions, and do all of these things. So I'm going to land it here because I know I'm just trying to pack it on because I was trying to get through when Brett was here, but I really want individuals to know that public domain words are real. Public domain terms and phrases are real. These companies will sit there and they will file a UDRP because that's the tool of choice. They don't want it to be on record that you went on ahead and you requested or you reached out to them about a domain, they bought it, and then it's on the record that they bought it from you. And then it sets the precedent that if anybody gets names that are even remotely associated with their business or their industry, that people are going to be able to come along and, just make money off of them. But I just don't want anybody in here to think that, just because you get a name and it's quote unquote a keyword and all of that other stuff, that a corporation can just come along and say, yo, we want this name. We're going to file a UDRP, and because they filed a UDRP, you have no chance to just have your details in order. Make sure you're on top of your stuff. You're not doing anything malicious. Here's one last little point. If you get a name and it's a particular name that could be conflicting, I want you all to use it.com, for example. It.com right now is offering third level domains, essentially. So you can go to registrars and register whatever name by it.com. If you have a name that could potentially be viewed as threatening and you don't have any malicious intent, consider reaching out to the company and gifting them the third level. Gift them any third levels that might be related to their company. So if it's a particular, cotton ball company, you might give them and say the extension is cottonball.com. We know that's taken, guys, but I'm just using it as an example. If it's cottonball.com and you're using it for something totally unrelated to selling cotton balls, then you might reach out to the cotton ball company and say, listen, just so we don't have any issues, I'm willing to go ahead and provide you with buy.cottonball.com, purchase.cottonball.com. I'm willing to provide it to you at no cost. Even if they don't accept it, it's still on the record that you made a good faith intent to make sure that there were no confusion, with you using a name and whatever it is that they're doing. So I'll land it there, guys. I thank you for listening to my rant. I'll try to go ahead and tune in the next time, Brett steps in. And Todd, thanks for passing the mic. Thank you, Namefi, Victor, and everyone else that took part. You guys are awesome.
Thank you for the tip, namer tips. Very, very helpful. Todd, you have your hands raised. Go ahead, Todd.
Yeah, and I know you want to shut down Victor. Yeah, it's nice seeing namer tips, and I know he's had firsthand experience. Like he said, you get UDRPs, you got to defend yourself. Certainly, well, I want to clarify one thing. They can't drag on the UDRP too long because the respondent has 20 days to answer back. So you got to answer back, and then of course the panelists can spend some time. That cotton ball thing threw me off. So you own cottonball.com and then you offer them purchase cotton ball. You don't have to say anything, but I was going to say what we mentioned earlier. Even though a name like cottonball.com, of course you can own it. But if you just had a meeting with a company and you're like, listen, I want to do business with you. You sell cotton balls. And then they find out you go register cotton ball and you contact them later that day and say, I want to sell it to you for $100,000. You could get yourself in a mess by basically saying, here's my intent. Now, what you do is you slow it down and you say, I registered this because it was generic. And I know several companies can use it. But as we were saying earlier, even descriptive and generic names, if you do something so crazy with it, and that even with those generics, you could still, get yourself in trouble. But what you wanted, anyway, it would be very limited because you'd have to be really goofy, and stupid, frankly, to fucking register generic and then take certain actions that could get you in trouble. Victor, the reason I didn't answer when I answered Paul earlier is because Paul and I are on speaking terms. So we're not talking right. I'm just kidding. Paul's like a brother from another mother. I don't know. He's not even here now. But I wanted to say it was something about that. Oh, David, finally, I'm done. David, isn't it funny that Arif thought what you commented was me commenting? So we've hung out together. It's just long enough to now where people think what David says is what Todd says. Victor, okay, I'm done. I was just wanting to lighten it up here at the end. It's good to see Namer Tips. Good to see Ahmed here. Of course, Arif, we can't get rid of him. It's like something, he's always around. Arif, I hope to see you here in an hour. We're going to start that other room. But Victor, a fantastic room today. Congratulations on getting Brett. He's awesome. I love to hear his stories. I can't wait to hear more.
Thank you very much. Thanks, Todd, for the nice word. And for everyone who is just not getting enough of this legal knowledge, please give Todd a follow. And then his room starts in an hour. Let's take a quick break and then we will all join there. And thank you so much. As always, let's enjoy domaining. And then we're here to serve you as Namefi team. Thank you very much, everybody.